Hello, everybody. Welcome to Know Your Money. I'm Bronwyn Weiner.
And I'm Craig Finch, and we are from Growth Financial Planning. We hope you enjoy our podcast.
Hello, viewers. Today we have Jakes from Wax Attorneys, who's going to help us understand the importance of having a will. Jakes, do you want to introduce yourself and tell us a little bit about you?
Hello, and thank you for having me today. I'm Jakes Myburgh from Wax Attorneys. We are a firm based in Randburg, Greenside, and as Bronwyn has said, we will be looking into the importance of having a will.
Hi, Jax. So maybe you could just start with telling us what is a will and what's the importance of having one.
A will is a document that you execute while you are still alive. I mean, after that, it will be pointless. It's important while you are alive to execute a will where you will stipulate exactly how your estate will be devolved. So that is how you're going to be, how your will be devolved with your heirs. That's your family members, sons, daughters, wife, mothers, sisters, whoever you want your will to be executed or to be devolved to.
So beneficiaries of
Your beneficiaries,
Yeah.
yes.
So,
And,
Jakes, do you need it in writing? I mean, do you have to write it down and do you have to sign it? What happens if you can't write it, or you still want the wishes to be executed, as you said? What happens then?
So in our law, we look at the Wills Act. That's when you have executed a will. And in terms of the Wills Act, there's certain formalities that you need to follow.
And what are those?
Those formalities are, you need to be 16 years of age. Once you are 16 years of age, anyone can execute a will, have a will drafted up, and it needs to follow the rules as per the Wills Act. And that stipulates that you need to have it in writing. You need to have 2 witnesses present. Anyone that's 14 years and older can be a witness to your will, and it needs to be signed by the testator. Now, the testator is you and me and anyone else that wants to draw up and have a will executed. And that's just...
And dated, right?
And
it needs to be dated.
Yes. But doesn't necessarily have to be dated, as long as the wishes of the testator is there and it has been signed by the testator, then that will be valid. But yes, we would say that it needs to at least be dated, but that's not really a formality.
So in my opinion, if you don't date it and you have more than one will, it can be quite difficult to revoke a previous will. So
it could have its implications, but that's where you will then need to, if after you've died, then that's your beneficiaries or the executor will then have to go to court and say all the previous will, because normally the last will if you have dated it or not dated it, could have been signed on your deathbed or anywhere else, and it was just really an urgency. But the will needs to you need to make sure that all the formalities have been followed, but it's not necessarily that it needs to be dated.
You said executor. What is an executor?
An executor is the person that looks after your estate. So the executor that gets appointed in terms of your will or in terms of the act. So if
you appoint anybody as an executor?
You can appoint anyone. Normally, you would appoint a family member or someone that has a financial background. Or
will the master accept it?
The master will accept, if it is in your will, it will be accepted. But the master, if you appoint a family member, the master will need to see that you are capable of executing the will in terms of the wishes, and that you have the expertise.
Sorry, Jax, what's the master?
The master of the High Court is a person that sits in Johannesburg or Pretoria or other offices, and they oversee the whole administration process.
Right.
So the master is essentially the overseer of the of anything estate related, the administration of the estates.
So Warren, you can't. People say I don't have a will. The government's going to take all of it. It's not true. The master controls. Well, make sure that all those formalities are properly in place and that the right people inherit your estate. The master makes sure that is carried out. Central office.
Assuming you have a will.
Yeah, so we'll talk about not
Yeah.
having a will because
Yeah.
that's another scenario.
Right.
But the master is sort of the policeman to make sure that what I wrote in my will goes to the
Happens.
right people.
Okay, that makes sense. Yeah. So
Yeah.
this is
You've got to have somebody to control it.
Yeah, assuming we have a will. Yeah.
Yeah.
Okay.
Yeah.
And
We're assuming now you have a will.
what I've heard before is that executors take fees.
Correct. The executor takes a fee. It's been prescribed in the administration of the Seized Act that an executor can take 3.5% on the entire.
Plus VAT.
Yes. So on the entire uh, estate, they can take 3.5%. So that's not.
It could be quite a significant amount of money if it's a wealthy
It could
individual
be.
who passes. And why? So then, why doesn't everyone just make a family member an executor?
Because, like I said previously, family members don't have the necessary expertise. So normally they would just say, I will appoint an agent or an attorney or someone else that knows how to deal with wills, because it becomes quite complicated.
I think the master can also refuse that family member if that family member is not able to show that they can administer the estate. There's things like tax has to be sorted out, transfer of properties.
Yeah.
There's advertising in the newspaper. There's a lot of steps that attorney like Jakes has to go through to make sure that you wrap up the estate, but there's a balance sheet that needs to be completed properly.
Yeah.
There's a whole lot of steps that if you're just a family member, you don't just arrive at the master and say, hello, I'm here. You've got to make sure you know how to do that administration job.
You
So
see,
it's very involved.
after a person has passed on,
Yes.
you have 14 business days to go to the master and tell the master the person has passed. So there's forms that needs to be completed, and those forms can be downloaded from the Department of from the Judiciary's website, and that needs to be filled out, taken to the master to register the death. And upon from that, the master, because you will have beneficiaries that will appoint someone as the executor as a family member. The master will look at that and then will make a decision whether the executor as nominated will be appointed. But in estates, we have two ways of appointing someone. The one is letters of authority. That's for any estate less than 250,000, and for estates more than 250,000, that's where they need a letters of executorship. So anything under 250,000 rand, the master will then decide who they're going to appoint. So there's no executorship, no family member getting appointed, only when it's over and above 250,000.
And that 14-day, if you don't notify them within the 14 days, what happens?
Nothing per se will happen. We had matters where estates gets reported years after. I had a matter recently where the deceased parents, which lived in Zambia, but they were South African citizens, had assets in South Africa. So my daughter came to us and she said, there's a policy in one of their names. Can we assist? So we then registered with that estate. So I had to go and do the death notices because that wasn't done in South Africa. Also, they were still shown as alive. So we had to first report the death, get the death certificate, go to the master, and that's been over 12 years. So nothing going to fall on that. So
12 years?
12 years, yes, for the one parent. And the other was,
Sure.
I think, 10 years.
And the policy's still there and still going?
The policy is still
what
going.
What kind of policy was it?
That is a life policy, but that was just really because the policy was in was to be made I think it was from a father to a mother, and then the mother passed away as well. So there's really no beneficiary, but
It would then fall to the estate if there's
it
no
falls to the
beneficiary.
estate, and we first have to now get the daughter as the appointed as the executor. But because she lives in Zambia, it's become a bit difficult because they wanted someone resident in South Africa.
So that's maybe another important point, is just to note, if you are going to choose someone as an executor, it is definitely more feasible to choose someone in South Africa.
Correct.
But
Otherwise,
you'd rather make sure that the executor is an approved person who does this all day long. You don't just make your family
I'm
member.
just thinking here, right? So how many masters are there in a province?
I think there's an office in most major cities.
Because how many deaths are there daily?
Oh, sure.
I think, I'm not sure about this.
Hundreds of thousands.
I'm just trying to understand
Plenty.
how they can keep up with a workload if it's
Yeah.
this complicated.
Yeah.
But
Well,
is
that's
there a
why
bit
they
of a
have
backlog?
that's why
Oh.
they have agents and yeah.
So how long
there's
does
not
it-
one master. He's not
Yeah.
only one
No,
person. It's a
how
big
many,
office.
that's
yeah,
where.
yeah.
But okay, so how long does it take sometimes to for use of a
Wind
better
the
word?
estate.
Yeah, I was going to say wrap up, but yeah, wind up an estate. then.
Normally, if it's an easy estate,
What would classify as easy?
if there's no complications. So if you have done your will, there's enough assets to be distributed between the heirs and the legatees. A legatee is someone that you have said, all right, I want to give you 10,000 rand. And I want to give you 10,000 rand. And then whatever remains is the residuary heir. And that is what is left in the estate, and that's what someone gets. So if the estate is, and we work with government organizations, and you have to advertise and all of that. So if you've done the advertisements in the newspapers, have advertised it again, because you need to advertise it twice. Second time is, first time that you advertise is for creditors to come forward. If no one comes forward, you start your letter L&D, it's liabilities and distributions account. You then submit that for the second time to the master, which gets held at a magistrate's court in the vicinity where the person has died. And if no one comes forward, then you can wrap up that estate. And
So-
it takes about 6 months.
6 months. Wait, I don't understand. I always thought that obituaries in the newspaper were a sentimental thing. They're not.
It's different from an obituary.
Yeah.
So an
Or
obituary,
how do you announce it in the newspaper? Where would you put it?
you'll put it in the notices as a legal notice. So where
And do you just have to put it in the local newspaper as to where that person lives, or does it go into a national newspaper? Or
best will be national, because your creditors could be all over the country.
But if someone doesn't do it nationally, is that a problem?
Yeah.
Or-
No, because you'll see, well, it's not going to be a problem, but you need to then advertise. If you do have it in a local newspaper,
yeah.
then you need to advertise it in the area where the person has died, for example, and where you might have lived, or where creditors could be situated, so that they are all informed. So I would say having the national newspaper publish that death notice is more important than having local newspapers, because someone could have missed it.
So,
and the executor does that, right? So it's their
The executor
duty.
does that, yes.
and so the creditors, let's use them for an example. If that person does owe money to creditors, how does that work with regards to the executor and dishing out the will?
So once you have published that legal notice, creditors have 30 days to come forward. If they don't, and you proceed to have the L&D account, which is the liabilities and distribution account, processed, but they can come forward at any time, but
Within the 30 days or even after that?
they can even come after that.
So Warren, the idea is that the L&D account, it's
Yeah.
basically a balance sheet when you pass away. Your assets, your liabilities. So
Yes.
the creditor will be a liability. So suddenly, I don't know, you owe a furniture account that nobody knew about. And then one of the furniture stores comes forward and said, this person owes us this. And then the executor had to take that into consideration, pay it, make sure there was a valid claim, and then they pay the creditors out. And the balance of the estate will go to whoever the heirs are. So it's very important that
So that's done before the heirs get any money.
yeah, they've got to pay SARS. They've got to
Correct.
SARS has to be paid. You have to do your final tax return with SARS has to be completed as well, because maybe
Your annual
SARS,
tax return.
Yeah, it's got to be up to date. So if you got back taxes, SARS the creditor, they'll get their money.
First.
And normally
Yeah.
SARS gets paid first.
They
Yes.
get paid
And,
first.
and what
yeah.
about just? I suppose maybe we'll do this in another episode, talking about tax, right? Okay, no, we'll do that in another
Yeah,
one.
so but also from a planning perspective, when we plan, you look at what the assets and liabilities are and what the costs are going to be to wind your estate up. We make provision for it. So as Jake says that 3.5 plus VAT, about 4%. You make provision for that in your whole financial planning and your estate planning exercise. And things like pension funds, retirement annuities fall out of that. So they don't touch it. So Jakes he won't charge that fee on a retirement annuity,
Yeah.
because that gets paid directly to the spouse.
Yes, okay, I
The
understand.
beneficiary nomination, or even an endowment policy.
Right.
Yeah.
And some of the tax-free products we do a tax-free through Allen Gray. There's a nomination of beneficiary. Jakes won't get involved in that as well. So that 4% falls out of that.
So basically, anything where you nominate a beneficiary, the executor doesn't have to be involved in or wind up or take a fee from that. So life policies, endowments, and that's why when it comes to planning, we would plan how much of your money is in a unit trust, or, should we be shifting it into an endowment because your beneficiaries need that money straight away. With winding up of an estate, all that money stays in there till SARS is done, till those 6 months.
So for example, a property
Yes.
that is then going to be divvied up between children,
Yeah.
that will form part of the executor's
Yes.
estate.
Yes,
Correct.
and will
Right.
only happen once everyone else has been paid. And if there isn't money in the estate, but there is the property has to be sold to pay SARS, and then you get the rest.
Wow.
So that's why having a life policy on endowments is so important, because it doesn't form part there,
Yes.
and it can get paid out and help your beneficiaries in those 6 months when the bank accounts are frozen and everything's locked
So
up.
money in the bank will go through the process that Jakes mentioned, the 6-month process. So it's
Yes.
probably minimum 6 months, because depending
Minimum
on the
6 months.
master,
It can take
can
longer,
take up to 2 years.
7 years, maybe.
Apparently
Yeah,
12 years for someone.
Yeah,
Be 12 years.
Yeah,
It's
there's
very
disputes on that. But so you can have all your money in the bank, and you can have a property,
Yes.
and you pass away, and you might be very wealthy in cash and very wealthy in property, but your heirs, your beneficiaries, will have to wait until the estate is wound up.
And if
What-
they rely on your salary and your money, it's all locked up.
What happens if you are your properties are in a trust?
Then the trust continues, so that it doesn't get affected by the will.
A trust doesn't form part of your estate.
Yeah. So that is maybe why people do that.
Yeah, there are a number of reasons,
Yeah.
but that could be, so that the trust is a living situation, so it'll continue.
So-
Jakes won't get involved in that either.
Right. Makes a lot of sense now. Okay.
Or maybe not to have a trust, but that's another
No,
whole
not the
discussion.
trust.
yeah.
I mean, when you said the balance sheets of assets
Yeah.
and liabilities. So if you are cash rich in the bank, and if you own multiple properties, but you actually have no living annuities or life or anything
Yeah.
No
like that,
life policies,
Yeah.
no
you have no
endowments.
beneficiaries named from family members. You're actually it's a nightmare when you're dead then for the people who are left behind.
No, exactly, because there's an immediate need for cash if you
Yeah.
pass away. Your family still needs your income, as Bronwyn says.
But it's locked up then. They
No,
can't access it.
But that's where we plan it, to make sure
Yes,
it's
we
life
do a
policies.
liquidity analysis. So how liquid are you if you pass away, that they are okay and they have that money for those few months or years
That's very
before all
interesting,
of
yeah,
that
yeah.
wealth that you have
Well,
built
until
up.
Jax came on today, I didn't realize that it was such a long process, and it could be such a long process, and also that it is, until your creditors are paid back, until you paid your tax return, no one can access the money. It's,
No,
it's stuck
exactly.
there.
Yeah.
And I think
And
what's
that's even the cash in the bank.
Yeah.
No, especially the
So
cash in
what
the
happens
bank.
if you have a joint account with your wife? Is she no longer allowed access to
I
it?
don't think there are joint accounts in South Africa, so there's no.
We'll just have another
you-
bank card.
But
Yeah.
she can't use it
No, I mean,
If it's
so
in his name.
because
Let's say he
that's
died, it's in his name.
Not necessarily, because it's your will and your death follows from how you were married.
yeah,
So in terms of your marital regime, if you're married in community of property, then the half share is hers, half share it falls in his estate. But just, I think she will be able to continue after just speaking to the master, explaining the situation that we need access to the money,
Right,
because
okay.
she's still, because the half of that belongs to her.
Yeah.
That's hers.
But it does get more complicated, and debit orders if they're going off that,
Oh.
the spouse's bank account, and that's why we're saying don't get an executor that is a family member, because all of this stuff needs assistance. You need help. You need to be told, okay, this needs to happen, that needs to change. Have you thought about this? Have you thought about that?
Well, my dad's a chartered accountant, so he's been the executor on my grandparents, for example, from my mother's side. And yeah, he did say it's not much fun to do it.
No.
Yeah, and then he understands how a balance sheet works, and he knows how to
It's a
draw
lot
it
of
up,
work,
and he
he
knows
said,
how to do
yeah.
tax probably. So even that, you've got other rigmaroles and other processes, like Jake said. The advertising in the newspaper, when do you advertise it? The two adverts have to happen. There's a lot of process and also properties have to be transferred from one spouse to another, and you need conveyance attorneys to do that.
So there's
So
transfer
it's
costs.
transfer costs for that as well.
Oh, so the more stuff that's left in assets rather than in policies, there's more costs that are going to come out of that as well then.
Yeah, exactly.
Because if you have conveyancing through the lawyers, they're going to take a piece.
Yes.
Is there a sales tax as well on selling the property?
No.
There's a capital gains
Capital
tax.
gains
Could be
tax?
capital, yeah,
Yeah.
could be capital gain depending on the property. Yeah,
And
yeah.
you do get 2 million on a primary res, like as an exclusion, and so it there's a lot more to it than just that. But I think the basis of this episode is having a will and just understanding those points that there needs to be 2 witnesses. It needs to be signed.
You need to be 16 years of age.
Need to be 16 years of age.
The witness
and-
can be 14 though.
yes.
Witnesses can be 14.
And then we would recommend, don't just say, I'm leaving all of this to this. You need to understand the implications if you leave everything to your child. And
And how you leave it.
yeah,
Yeah,
can
because
get into it.
children underage, how are they going to run those assets? They won't be able to. So you need to have a trust drawn up in your will as well. So the important, I think, what Bronwyn's saying is draft a will correctly, and make sure the executors are like Jakes, who know what they're doing. Don't make it a friend or a family member, because there's a lot more involved. And when your assets are distributed, we're going to help you with that. We're going to say, this is actually what's practically going to happen. But it's important to have the will and make sure the will is kept in a safe place as well, right, Jakes?
It needs to be kept in safe.
Can it be filed?
Yeah, but it
And
must be.
so you don't have to have the physical copy anymore. You have to have the physical copy.
You need, because the master will need an original when that gets submitted. So if you have a will, make sure that it's kept safe.
and you can have more than one original. So you can keep an original and the other original can be at someone else's house.
Correct. It was certified as a true copy of an original. But you're not going to sign 2 different ones. You'll just sign one and
But
certify.
can you have a photocopy? Will the master accept that?
No, the master will want to be
You
original.
want, and if,
But a
if
certified copy.
A certified copy will do, but the master will give you directions on how they want it. So
and
after you file your-
if the only copy is a photocopy, for example,
Yes.
a scan copy or an email copy, and there's no physical paper, wet signature copy, what happens then?
Then you will have to go to the High Court. The High Court will then decide whether the master can then accept the
Is that
copy.
you or is that the executor that does that?
The executor will appoint an attorney, and the attorney will then start the process of just going to the High Court.
So some more
All
costs.
estate matters need to go through the High Court. Not
So that's an expensive process if you
that
haven't
could
got
be
the
an
original.
expensive process. So it's
So
better-
important to keep your will.
Very important, because otherwise
safe
this wealth
place.
that you've managed to accrue over your life is slowly being eaten away.
Yeah. But I think it's done. Well, it's definitely the master's there to make sure that your heirs are the right people.
Yeah.
Because what's important is before you die, and I know people don't have time for that because life happens, is just update a file every month so that your heirs and family members are able to access that fairly quickly after you've passed. Because you don't want someone scramble around looking for documents, having to ask, don't know what creditors they are, and get surprises afterwards. Just keep a document, a file, with all your documents, update it every month with what's needed, and just make life easier for whoever will be left behind. Because you have someone that's mourning and they still have to figure out, how am I going to deal with this estate?
Sorry, just last thing from me, but this actually happened to a good friend of my wife's. Her brother, so her friend's brother, passed away in his mid-30s from a heart attack, and he was in charge of the finances and looked after everything from debit orders to school fees, everything. And suddenly she was mourning and had to come up with answers as to where money goes where. Yeah.
And that's why in our planning practice, we have that all for you. We put it together for you. You have somewhere where you can go. So I think to wrap it all up, have a will, get some financial advice from it, and understand who your executor is.
Thank you, Jakes.
Only a pleasure. Thank you
Very
for
interesting.
having us.
Thank you.
Only a pleasure.
Thank you for listening. If you have enjoyed this podcast, would like to subscribe, please visit our website, www.growthfp.co.za. The information we have provided in this podcast is our personal opinion. For more detailed information, please discuss your financial situation with a financial planner.